Hello, my name is Andrew Grabowski, estate planning attorney with Shea Aiello Law Firm. If you're watching today's video, you have been selected in a fiduciary role for one of your friends or family members in their estate plan. I'd like to start off by thanking you for being in this role, as there will be some steps and some things that need to be done when the time comes, and I'm thanking you on behalf of your family member as well. The topic of today, of course, is the estate plan that you've been appointed in. And my goal is to articulate exactly what those roles are, what responsibilities entail, and also to give you a friendly and handsome face to contact if you ever have any questions about those roles or about your own estate planning. A good estate plan is going to have not only after-death documents such as a will, such as a trust, which of course we'll get into as we go through, but an estate plan is also going to have the basic lifetime documents as well. So for today's discussion, or for today's video, I'm going to walk you through those roles, what those documents mean, and it's something to keep in mind. You may be appointed in some of these roles, but not in other roles. And that's a further discussion you can have with your friend or family member who has appointed you, as they will also have memos or different copies of these documents to give to you as well. Starting with powers of attorney, there are two of them. And typically they only kick in upon incapacitation. Coma, vegetative state. My grandfather had Alzheimer's. He wasn't able to take care of his basic day-to-day things. What are those basic day-to-day things? Well, in the general durable or financial power of attorney, who pays your bills? Who files your taxes? Who opens your mail every day? Healthcare power of attorney, who makes treatment decisions? Who can access your medical records? Who gets to make your life support wish, knock on wood, if it ever got to that point? The basic day-to-day financials, the basic day-to-day healthcare decisions that each and every one of us have. These documents allow you to appoint somebody to make these different decisions. I typically recommend multiple individuals. So I'm going to just use old cousin Tony as an example, where we appoint cousin Tony first. However, let's say cousin Tony passes away before you. Let's say cousin Tony doesn't want to do it. Let's say cousin Tony's on the other side of the world when a decision needs to be made. Well, that's then where you have Uncle Bob listed as a backup. So a first, a second. Typically I'll recommend multiple backups. The more the merrier, because it just creates a trickle down or a shelf life. In the healthcare document, just a quick pointer, those advanced directives or living will or DNR type provisions, you may be familiar or comfortable with those terms, allow the individual to tell the patient advocate or healthcare power of attorney exactly what they would want in certain situations. So not necessarily every decision needs to be made by these appointees. In the document, they're laid out what the roles are and ultimately what the person wants to see happen. The financial power of attorney will work at the bank. The healthcare power of attorney will work at the hospital. Peace of mind planning in the event incapacitation. Without these, a probate court gets involved, which is only going to lead to time, costs, and who knows who gets appointed in these roles. Might not be the person you would trust in a million years. We've discussed lifetime or powers of attorney, which appoint someone to handle the basic day-to-day decisions if incapacitated. Segueing to after death and discussing the different documents that are in place to handle the after-death decisions, I want to first briefly talk about probate court. What it is, what it does. Probate court is the jurisdiction of court that handles things when the right documents are not in place. Specifically, it's a judge who doesn't know you or family dynamics deciding who gets appointed in different roles. The after-death roles to focus on would be the executor, otherwise known as a personal representative, and the guardian. The executor is the person who administers the estate, who liquidates the investments, who pays the taxes, who sells the real property. The guardian is the individual who takes care of the minor children, if in fact there are any minor children involved in this dilemma. The second thing a probate court judge is going to do is distribute your assets, or decide where your assets should be distributed. Michigan law will govern. However, that judge will independently decide. The problem with a judge deciding is it very well may not go to the individual that's wanted to receive these assets. And that could be for money, that could be for tangibles, that could be for real property. When probate court gets involved, on top of the uncertainty as to what happens in the rolls and where your assets go, the court is going to eat up a significant portion of the estate. AARP tells us between 3 to 10%. And to probate the estate, it's going to take somewhere between 9 months to 2 years to do so. Once again, another AARP statistic. Of course, it can be less. It could be more. Typically, where we see longer and a greater cost commitment comes when family members come out of the woodwork, or when individuals come to argue as to why they should be receiving an asset. And once again, like we talked about before, it's going to be a judge blindly deciding who's in charge and where do assets go. In talking about guardianship of minor beneficiaries or minor children, additionally, that's the age of distribution in the state of Michigan. So as those minor children come of age 18, they not only wouldn't need the guardian anymore, but they also would then be distributed all the assets. At age 18, I would not have made the best decisions with assets. Most 18-year-olds, I would argue, would be very similar. So I wanted to articulate and or describe exactly what probate is, why it gets involved, and ultimately ways to get around that or to expedite and make things more efficient when the time comes. Fortunately, in this situation, the proper estate planning documents have been implemented. The document that I speak of is a revocable living trust, with the main point being it has the ability to avoid probate court. How this is accomplished, assets get transferred into the trust. The individual who set it up has not lost control. You have not gained any control. The person who set it up is completely in charge for the rest of their lives. They can spend, they can save, they can refinance, nothing changes whatsoever. How do they accomplish probate? Is they transferred all the assets into this company, is how I want you to think about it. They're the CEOs of the company, they're in charge. Nothing changes. When they pass away, the company continues to live with a new person in charge. That's you, successor trustee. As a successor trustee, you take over the company, manage the investments, pay the bills, eventually distributing pursuant to the rule book that has been established. Who receives the assets? What are backup plans if a beneficiary were to pass away? Additionally, when do distributions occur? Whether it be ages, whether it be contingencies like upon graduation from higher education, money's distributed, all the while the trustee, you, have the ability to make distributions ahead of time. Pay for that college. Pay for an automobile. The things the individuals who originally set it up would have provided for. Still very flexible, but also, once again, with a rule book that needs to be followed. Main point, avoiding probate by transferring assets in. No control lost, no control gained. But when that person passes away, the successor trustee will now take over and manage things. Distribute assets. In addition to a revocable living trust, there is also a will in the trust estate plan. While this may be confusing, as to why do you need a will when you have a trust? Well, you need it for two reasons. First off, the will is the document that allows the appointment of a guardian. The guardian is the person who does the basic parenting, helping with homework, driving to soccer practice, tucking in the minor child until they turn age 18. The second reason you need a will, and this could very well clear up any confusion you have around will versus trust, the will is called a pour-over will. And this is not the traditional will that you think of or that everyone thinks of when we say will. The pour-over will merely serves as a backup plan or a safety net in the event there was an asset that had not already been transferred into the trust during the individual who set it up's lifetime. So what the will instructs the judge to do is to take the asset that had not already been transferred in. Maybe it was oversight. Maybe it was an inheritance after the fact. For whatever reason the asset was left out, the will tells the judge to take that asset and transfer it in. If you are acting as the trustee of the revocable trust, in all likelihood you are also the person in charge of the pour-over will. Not necessarily guardianship, because taking care of the kids and managing the money are completely different roles. However, you may be in both. So the will serves as a backup plan just in case the assets have not been appropriately transferred. It also handles guardianship in the event there are minor beneficiaries. To conclude, I want to thank you for spending a few minutes watching this video and learning about the roles and responsibilities that you have been appointed. As a fiduciary, we want to offer you the opportunity to complete your own power of attorney documents at no cost. If you are interested, just sign up below so that we can reach out to schedule you for a complimentary consultation at any one of our 11 Michigan offices. This would also be a great opportunity and time to discuss any other documents that may be applicable to you at no cost obligation. I want to once again thank you for joining me, and please reach out with any questions, comments, or issues that you have.